May it please the Court, in this hallowed chamber, where the weight of our Constitution is translated into living principle, we gather under solemn circumstance to examine not only the issues of law before us, but the remarkable display of intellect and integrity that has unfolded within these very walls. On this day, the eyes of the nation are not merely fixed upon a docket number or a sterile caption at the top of a brief. They are fixed upon an exchange that has captured the public imagination and reminded us all why the law, when animated by courage and clarity, remains one of the noblest instruments of our democracy. I speak of the moment when Justice Stephen Breyer, a jurist whose life's work has been devoted to careful reasoning, institutional respect, and the steady cultivation of judicial wisdom, openly and unmistakably signaled his respect for the brilliance of Representative Jasmine Crockett, a respect so evident, so genuine, that it seemed to momentarily arrest the very movement of time within this courtroom. As she rose to address issues that thread through the core of our constitutional experiment, issues of fairness, equality, separation of powers, and the lived realities that test the promises of our founding documents, there was no bombast for its own sake, no theatrics designed merely to provoke applause outside these walls. Instead, there was a disciplined, deliberate, and devastatingly clear articulation of principle, built on precedent, anchored in text, and tempered by a practical understanding of how law touches human lives. The gallery, often restless with whispers and shifting attention, grew still. Counsel at both tables, who might on another day be inclined to measure every word primarily by its strategic advantage, found themselves listening with the kind of focus reserved only for those rare moments when someone manages to cut through the fog of complexity and speak directly to the heart of the matter. And it was in this environment rich with history, dense with expectation, that Justice Breyer's reaction became so telling. Here was a justice who has spent decades immersed in statutory interpretation, administrative law, and the delicate balance between judicial restraint and judicial responsibility, and yet he was visibly struck, not by a novel gimmick or a rhetorical trick, but by the sheer coherence of Representative Crockett's argument. His posture shifted, his gaze sharpened, and where there might once have been the analytical distance of a seasoned observer, there emerged instead the unmistakable engagement of a mind that recognized it was encountering something worthy of profound consideration. It was not the deference sometimes granted to rank or title. It was the respect that one serious thinker accords another when confronted with reasoning that cannot be casually dismissed. As she wove together historical context, statistical reality, and constitutional doctrine, she did so with a fidelity to truth that reminded this court that the law does not exist in a vacuum. She called upon our collective memory of past injustices, not to relitigate them in some abstract sense, but to illuminate the stakes of the present dispute and to show how the decisions made here ripple outward into communities, into homes, into the lives of those who seldom see the inside of such a chamber, yet feel the consequences of its rulings every single day. One could sense, even without a transcript, that this was advocacy elevated to its highest form, not theatrical outrage, but moral urgency, not scattershot accusations, but carefully assembled facts, not hollow invocations of justice, but a concrete roadmap of how justice might be vindicated through the tools the Constitution itself provides. And when her argument reached its pinnacle, when she distilled pages upon pages of complex legal reasoning into a series of statements so plain, so unadorned, and yet so undeniable that they seemed to hover over the room, the air itself seemed to change. It was as if the walls, long accustomed to the ebb and flow of argument, paused to absorb what had just been said. The court reporters, their fingers dancing over keys with trained precision, scarcely seemed to breathe. The clerks, those quiet custodians of analytical rigor, suspended their note, taking for a fraction of a heartbeat. And in that fraction of a heartbeat, something rare occurred. The court, in its entirety, appeared to recognize that Jasmine Crockett had not merely done well, she had done something extraordinary. This recognition was crystallized in the demeanor of Justice Breyer, whose expression reflected both admiration and introspection, as though he were simultaneously acknowledging her brilliance and recalibrating his own understanding in light of it. This was not a concession of authority, but an affirmation that the pursuit of truth in the law knows no hierarchy except the hierarchy of logic, evidence, and principle. His respect for her was not a fleeting gesture. It was the natural response of a jurist committed to intellectual honesty, faced with an argument that met and matched the highest standards of this institution. And so the courtroom fell into a silence that was not empty, but full of meaning, full of consequence, full of the unspoken agreement that something important, something enduring, had just taken place within these walls. Your Honors, as we turn our attention more closely to the character of that moment and the reaction it produced, we must appreciate that what rendered the courtroom frozen was not spectacle, not controversy for its own sake, but the unmistakable collision of rigorous thought with undeniable truth. Representative Jasmine Crockett did not approach this court as a supplicant begging for token acknowledgment. She approached as an equal participant in the ongoing project of constitutional interpretation, armed with the tools that this republic promises to all who are willing to study, to struggle, and to stand firm in defense of principle. She marshaled case law with the ease of one who has read not just the holdings, but the reasoning behind them, tracing how doctrines evolved and where they had been stretched or neglected over time. She invoked legislative history not as a substitute for clear text, but as an interpretive aid that helped to illuminate why certain provisions were enacted, whose interests they were intended to protect, and how those interests might be undermined if the law were read too narrowly or applied too mechanically. Most importantly, she did something that far too few advocates manage. She connected the abstract language of rights and duties to the lived experiences of those whose voices are often absent from these proceedings. She spoke of communities whose faith in the justice system is fragile because history has taught them that the scales do not always balance evenly. She spoke of individuals who, though nameless in the captions and invisible in the official record, stand to gain or lose everything depending on how this court chooses to frame the issues before it. In doing so, she did not attempt to manipulate emotion at the expense of reason. Rather, she showed that reason is incomplete when it refuses to look at reality. And it was precisely this integration of reality with doctrine that gave her words their extraordinary power. Justice Breyer's reaction, then, can only be fully understood against this backdrop. Here was a judge renowned for his belief that the law must be workable, that it must function in the real world and not just on the pristine pages of a casebook. As Crockett spoke, it was evident that she was not merely appealing to his sense of fairness, but engaging directly with his judicial philosophy. She presented data and examples that illustrated the practical consequences of differing interpretations. She acknowledged counterarguments with candor before dismantling them with logic, showing that she had not only anticipated the court's concerns, but had taken them seriously enough to respond with substance rather than slogans. In this respect, she did not seek to flatter the court. She invited the court into a conversation worthy of its stature. And Breyer, attuned to the rare harmony between theory and practice in her presentation, responded with the one gesture that carries the greatest weight in a room like this. He listened intensely and without distraction. His questions, when they came, were not designed to trip her up or to display his own erudition. They were probing, yes, but also respectful, as if he were testing the strength of a structure he already suspected was sound. Each answer she gave reinforced that suspicion. She did not retreat from complexity. She leaned into it, showing that the nuance of a problem does not excuse inaction, but demands better solutions. Her composure under this questioning, her ability to respond not with rehearsed sound bites but with thoughtful engagement, signaled to everyone in the courtroom that this was not a fleeting performance, but the manifestation of deep preparation and authentic conviction. And so, when at last her exchange with the bench concluded, a new kind of silence descended. It was not the awkward silence that follows confusion, nor the tense silence that often precedes a contentious ruling. It was a reflective silence, the silence of people processing, rethinking, and, in some cases, quietly conceding that their expectations had been surpassed. Counsel for the opposing side, who may have entered the courtroom assuming they would face a conventional argument, now had to grapple with an opponent whose mastery of the material had reshaped the terrain on which the case would be decided. Observers in the gallery, some of whom might have arrived with only a vague understanding of the legal questions at stake, left with a vivid sense that they had witnessed something historically significant. And at the center of all of this stood Justice Breyer, an embodiment of the institution's continuity, reacting with the humility and grace of one who understands that respect is not diminished when it is extended to those outside the traditional centers of power. Rather, it is elevated. His respect for Jasmine Crockett's brilliance was not expressed in grand declarations. Judges rarely indulge in such theatrics, but in the subtler, more telling cues that those familiar with courtroom dynamics instantly recognize: the deliberate pace of his questions, the length of his pauses, the small but unmistakable nods as her reasoning aligned with the deepest currents of constitutional principle. These cues traveled through the room like a quiet signal, telling everyone present that what they were hearing was not merely competent advocacy, but exceptional advocacy. That is why the court seemed to freeze not from fear or uncertainty, but from awe. For in that moment, everyone understood that the exchange between Justice Breyer and Representative Crockett had transcended the particular dispute before the court. It had become a testament to the enduring power of informed, courageous speech in a system that, at its best, welcomes such speech not as a threat, but as a vital contribution to the search for justice. Your Honors, if we are to understand the full magnitude of what transpired when Justice Breyer's respect for Representative Jasmine Crockett's brilliance became so vivid that it seemed to suspend the very motion of this courtroom, we must look beyond the immediate exchange and consider how moments like this reverberate through the larger architecture of our legal and democratic life. Courts do not exist in isolation. They stand at the intersection of law, history, and public trust. When an elected representative steps into this space not merely as a political figure, but as a disciplined, deeply informed advocate for constitutional principle, and when that advocate presents arguments so lucid, so meticulously grounded in doctrine and fact, that a justice of this court responds with visible, unmistakable respect, something profoundly healthy is happening within the system. What the public witnessed, what everyone in this chamber felt in the quiet after her words, was a reminder that our institutions are capable of genuine dialogue, that the distance between the people and the judiciary can, at least for a moment, be bridged by the sheer force of reason. Representative Crockett did not seek to bend this court to her will by invoking partisan passions or personal attacks. Instead, she invited the court to meet her on the highest ground available in our civic life, the ground of text, precedent, logic, and moral clarity. She laid before you a record that did not rely on exaggeration, but on carefully chosen facts. She invoked cases not as talismans, but as carefully fitted pieces in a larger mosaic of constitutional meaning, and she framed her arguments not as demands, but as urgent questions about whether the principles we claim to honor will be allowed to function in the lives of those most affected by your rulings. In the hush that followed her remarks, the message that filtered through the wood and stone of this chamber was that the law is at its strongest when it is challenged by minds willing to engage with it fully, and at its weakest when it hides behind formality to avoid such engagement. Justice Breyer's reaction, his attentive posture, his probing but respectful questions, the subtle shifts in expression that those of us familiar with courtroom dynamics instantly recognized signaled that he did not perceive her presence here as an intrusion, but as a contribution, perhaps even as a necessary corrective to any temptation toward complacency. The court froze, yes, but it froze in the way a body freezes when struck by a sudden realization that the person before it is not simply reciting familiar lines, but reframing the conversation, opening a new vantage point from which the law itself can be seen and evaluated. For young advocates watching, for students of law who will read about this exchange, for communities who have long wondered whether anyone who speaks with their cadence, who carries their history, can stand here and not merely be heard but respected, this moment carries incalculable significance. It tells them that brilliance is not confined to any one zip code or pedigree, that when preparation meets purpose, when study meets courage, the walls that once seemed impermeable can, in fact, become permeable to new insight. It tells them that a courtroom can be both a guardian of tradition and a stage for transformation, and that the justices seated above are not marble statues immune to persuasion, but human beings tasked with the solemn duty of listening, weighing, and sometimes revising their own assumptions in the light of better arguments. And if we listen closely, we can discern another message encoded in that silence. That respect is not a gift handed down from on high, but a recognition earned through substance. Representative Crockett earned that recognition not by asking for it, but by compelling it through the clarity of her reasoning, the integrity of her evidence, and the moral seriousness with which she treated the issues at stake. She respected the court enough to bring her very best. The court, in turn, respected her enough to treat her not as a mere guest in its domain, but as a formidable participant in the work of constitutional meaning-making. This is what it looks like when democratic institutions function as they should, branches of government in deep, rigorous conversation, each checking and enriching the other, not out of rivalry, but out of shared commitment to the rule of law. And so, your honors, when we say that the courtroom was frozen, we are not describing paralysis, but attention, the sharp, total attention that arises when truth, discipline, and courage converge in a single voice. In that stillness, the law felt alive again, not as a relic of past decisions, but as a living promise subjected to fresh scrutiny and renewed understanding. It is that promise, and the responsibility that comes with it, which now rests with this court as it considers not only the narrow disposition of the case before it, but the broader signal it sends about whose voices are truly welcome in this sacred space. May it please the court, as we move to close this argument, let us return with deliberate clarity to the image that has captured so many hearts and minds. Justice Stephen Breyer, a seasoned and venerable jurist, sitting in reflective silence as Representative Jasmine Crockett concludes an argument of such power that the entire courtroom seems to fall into a kind of reverent stillness, as though the very air were waiting for the law itself to respond. That image is not merely symbolic, it is instructive. It shows us that respect in this chamber is not automatic, not guaranteed by title or tenure, but earned anew each time someone stands before you with the courage to present a fully formed, rigorously argued, and morally anchored case. Jasmine Crockett did exactly that. She stood here as a representative of the people, yet she spoke with the precision of a seasoned litigator and the depth of a constitutional scholar. She traced the lineage of the legal principles at stake, showing how they had developed over time and how, if misapplied today, they could betray the very people they were meant to protect. She illuminated the human reality behind the abstract doctrines, reminding us that equal protection is not just a phrase in a legal opinion, but a promise made to every person who looks to this court for fairness rather than favoritism, for justice rather than mere justification. And Justice Breyer, by listening with such visible seriousness, by allowing his reaction to register in ways that even lay observers could sense, elevated this exchange beyond the realm of ordinary advocacy and into the realm of civic example. His respect for Brilliance did not diminish his role. It strengthened it because it showed that this court remains capable of humility, of openness, of being moved by merit wherever it appears. The courtroom froze, yes, but in that freeze we saw not fear but possibility. The possibility that the lines between branches of government need not be walls of hostility, but channels through which insight and accountability can flow. In concluding, therefore, I submit that this moment, this encounter between Justice Breyer's seasoned judicial mind and Representative Crockett's fierce, disciplined brilliance, should be understood as a testament to the best of what our system can produce. It tells every future advocate that if they come into this courtroom armed with facts, with history, with law, and with a commitment to truth that refuses to bend to convenience, they too can command the attention of the highest court in the land. It tells every member of the public that their voices, when channeled through representatives and advocates who do the hard work of preparation and learning, can reach even these lofty heights. And it reminds this court that its greatest strength lies not in insulation from challenge, but in its willingness to engage with the strongest arguments presented by those who dare to stand at this lectern. The respect Justice Breyer showed for Jasmine Crockett's brilliance should serve as a beacon, signaling that this institution is at its noblest when it listens most carefully, not to flattery, not to noise, but to the clear, insistent call of principled reasoning. Let this case and the memory of this exchange reaffirm that when the people's representatives bring their best work before you, they are not intruders at the gates of justice. They are partners in its pursuit. Let it reaffirm that the courtroom's silence in the wake of such an argument is not emptiness, but fullness. The fullness of ideas colliding, of perspectives broadening, of the law itself being tested and refined so that it may better serve the living reality of those bound by it. And finally, your honors, let it reaffirm that in this republic no chamber, however august, is beyond the reach of a brilliant mind speaking truth with courage. Representative Jasmine Crockett did that here. Justice Breyer recognized it. The courtroom felt it. And history, I submit, will remember it. For all these reasons, and with deep respect for the role this court plays in our constitutional order, I urge that your decision reflect not only the technical correctness of the law, but living principles of fairness, dignity, and accountability so powerfully articulated in that frozen, unforgettable moment. May this court's ruling honor the brilliance it has witnessed, the courage that brought it forth, and the people in whose name we all stand here today.